Yes, counsel. Good morning.
Good morning, Your Honors. Andrew Crouch on behalf of Luis Figueroa, who appeals of convictions out of the Middlesex County Superior Court. This case involves two contrasting views of the witness intimidation statute and two contrasting views of what the legislature intended the scope of that statute to be. We are focused at this hearing on specific language within Section 13b, and that language is, what is the definition of criminal proceeding of any type, and does that did the legislature intend to, and does the language provide for an extension to the relationship between a parolee and a parole officer, specifically relating to statements made, misleading statements made by the parolee to the parole officer, and whether the legislature intended for that to eventually lead an individual to possibly face incarceration for up to a 10-year period of time.
These are misleading statements about a parole violation.
Correct, exactly, about a parole violation. There is no dispute that there is an absence of a criminal investigation here, that there's no criminal activity. We are focused solely on whether the conduct in this case, whether the statement in this case that he was not at Torelli Terrace on October 31st, 2007, constituted a violation of his probation, and whether or not him offering that misleading statement would be that violation.
Well, when the legislature added parole officer in 2006, right? What would, if you read criminal proceeding of any type as narrowly meaning a court proceeding, which is how I think you read it, right?
Correct.
What would be the point of adding the parole officer? Parole officers, in my experience, are not usual witnesses in criminal cases.
They can be, and I do have a couple.
Anybody can.
Sure, no, but there are cases, I think, that with greater frequency that they do become involved in the criminal justice system. For example, parole officers frequently do checks to determine whether a sex offender is properly registered, and they will actually go out to somebody's home, make sure they are living there. I've had cases where parole officers go and they eventually end up testifying at trials based upon the failure to register statute, saying that I went there, the individual was not there on that day. Now, if the offender, the defendant in that case, were to somehow threaten or interfere or try to mislead in that process, that would be both possibly a criminal investigation, and more specifically, certainly would be a criminal proceeding.
But let me probe that a little further. Section 2, C2. If someone misleads a person who has knowledge or information related to a parole violation, that's a crime.
Under
it's whoever willfully misleads a person who is aware of information of a violation of a condition of parole. All right, why would the legislature have included that if parole proceedings were not within the umbrella of the statute?
I'm sorry, which section are you looking at?
CII. Misleads a person who is aware of information relating to a violation of a condition of parole.
Yes. So this still is subject, though, to the language that comes after it, and that language being the criminal proceeding.
Right.
And that is really what we're focused on. And I would suggest that both the decisions of this Court and out of the United States Supreme Court make clear over the course of many decades that parole is different from criminal, and that is from either not having the right to counsel.
It's different than a criminal trial, for sure, but is it within the umbrella of the criminal justice system?
I don't think I would suggest that the language is not criminal justice system, it is criminal proceeding. And I would suggest that under that language, under the statutory rules of statutory construction.
Criminal proceeding of any type?
Of any type, correct. And I would suggest that when we look back at the case law, as I noted, out of both this Court and out of the United States Supreme Court, it makes clear that there is this distinction between these two spheres, that parole violations do not benefit from the panoply of rights that are extended in criminal cases.
What's that got to do with this case, that there are different rights, due process rights in different levels of proceedings? How's that relevant?
I think it's relevant in the extent that we look at what the definition is and what the definition of criminal proceeding is and what the legislature intended. And the legislature,
we're looking at, yes, and we should look at what the legislature intended. And I guess my question to you is, why would they have included all of these people that would know about parole violations if they didn't intend that parole revocation proceedings were part of criminal proceedings?
I would suggest that, as I noted, the case law suggests that criminal proceedings are different from parole proceedings. And in this sort of situation, that exists entirely within the executive branch. It's not in the judicial branch. It does not involve any of the prior players from the criminal proceedings. Instead, it involves these other individuals. And as I noted to Justice Botsford, there are circumstances where a parole violation or information about a parole violation will be relevant to a criminal trial, will be relevant to a criminal investigation. I would suggest the legislature, in enacting these amendments in 2006, had a very specific purpose, and it was looking at addressing gang violence and the increase of intimidation that was occurring in courtrooms across the Commonwealth for witnesses involved in either criminal investigations or in actual criminal trials. Here, there's nothing to suggest that the legislature intended to so vastly expand the scope of the intimidating a witness statute to include criminalizing a single misstatement or a single misleading statement by a parolee to a parole officer to the extent that they're looking at a 10-year period of incarceration. I would suggest under the rule of lenity, in terms of looking at ambiguous language, to the extent that the Commonwealth even refers to this as a quasi-criminal proceeding. It concedes it is not a criminal proceeding on its face, but it is quasi-criminal.
But liberty is at stake, for sure.
Yes, it is.
Prison, liberty is at stake.
It is. And I would suggest that in looking at that particular language, in terms of rolling, even at a baseline, rolling it into the rule of lenity and looking and weighing those two options, an individual who is in Mr. Figueroa's place is not going to be put on notice by this statute that that making a misleading statement to his parole officer is going to land to him a 10-year felony. I think that is not what besides the language of the statute and the legislature's intent, I think under the rule of lenity that is sufficiently ambiguous to not provide him sufficient notice.
And let me see how far you're prepared to go with regard to that. Let's assume that in this case there was a claim of parole violation filed with the parole board, and the defendant threatened the parole officer and said, if you testify at that parole hearing, I will injure you. Violation?
I think that there are a couple of things. One, that would be certainly a violation of parole. Second of all, it would be a violation of criminal law in terms of threats to commit a crime. As in Hamilton, there are already existing remedies within the criminal law to address issues such as threats made to a parole officer absent a criminal proceeding, and I would suggest that it would be under that and would not go under the existing, under at least the language that the legislature has set forward so far.
Okay, so you would say not a violation of this statute?
Not of this statute, but certainly of parole and certainly of other statutes.
So your argument then is that a parole proceeding is not a criminal proceeding, and it's not necessarily, or is it an alternative argument that there was not yet a parole proceeding when the misleading statement was made because there had been no notice of violation?
Correct. And the parole officer in this case, Ms. Kozak, indeed testifies that she then goes back and speaks with her supervisor, and they're trying to make a determination of what exactly to do at that point, and that is only then that the ball starts rolling down that area. But there is no referral to a district attorney's office or a prosecuting authority. There's no suggestion of a criminal investigation.
But your argument isn't that because there was no pending parole proceeding, the statute doesn't apply. Your argument is it simply doesn't apply to parole proceedings, pending or not.
That would be my argument, yes. And I would suggest that this is not the legislature here was not trying to address some sort of substantial problem existing within the parole system, because if anything, I would suggest that the legislature, that adopting the broad scope view here, that parole proceedings do fall under the general umbrella of this criminal proceeding of any type statute, would actually fundamentally undermine the parole system, because parole is based upon a system of graduated sanctions. That is for the parole officer and the supervisor and the agency to make independent determinations, as it has been imbued with the discretion by the legislature, to determine the severity in the context of a parolee's entire history for a particular violation. Now, if somebody comes in and says, I was 5 minutes late, he was 5 minutes late for curfew, and he misleads his parole officer about that, I don't believe that the legislature had intended for that individual to face a 10-year felony penalty, as opposed to allowing the parole board to actually exercise the executive discretion it was given by the legislature to say, look, in the course of this, we'll give you a sanction of your home monitoring for 1 month, or trying to make a determination you need to go to other programs or counseling based on that. That is what the whole system of parole is set up to address. It is not set up to just allow this to go into a criminal system. And I would also respectfully disagree with the Commonwealth and its supplemental memorandum that somehow parole officers are going to be still maintain the discretion to determine whether or not to make that criminal referral. I would suggest that in this political environment in which we live now, a parole officer, if they know of a criminal violation and a misleading statement, if the court agrees with the Commonwealth's view, will be that criminal violation, they're going to be professionally obligated to provide that information to a district attorney's office. Whether that gets prosecuted is another determination, but that is the scope of where we are looking at if that point of view is adopted.
I take it your point would be, assume hypothetically that the district attorney knew of this. Your point would be whatever the parole officer wanted or didn't want wouldn't matter, because the charging decision is going to be up to the district attorney.
It definitely would, and that takes it out of the hands of the parole officer, and frankly takes almost all of the discretion out of, I mean, a lot of violations have to do with misleading parole officers, with, lying about whereabouts or about, attending counseling or something like that. This is just so vastly expands the scope of this statute. And I would suggest if the legislature had indeed intended to make misleading an official of any form within the government an offense, they had a simple composite in the federal law looking at that statute, section 1001, in which it makes clear that lying to a legislative or an executive or a judicial
1001
official.
of what chapter?
18.
But
yes.
that actually requires it to be a false statement, not merely a misleading statement.
Right, but this, yeah, so, but it's sort of a composite to look at in terms of an analogy. It could have made it much more clear, even at a baseline here, as I suggested. If we look at the jurisprudential history, we look at the legislative history, and we consider the rule of lenity, Mr. Figueroa is not put on notice that just making a single misleading statement to a parole officer about his whereabouts is going to lead him, as I noted, to face a 10-year felony. That, I don't believe, is what the legislature intended, nor is that borne out by the history nor the particular language of this statute.
Do we have any legislative history? I mean, this is referred to as a witness intimidation statute, but you correctly point out that it is essentially broader, or arguably broader, even than a false statement statute, because you can be misleading without being false.
There have been some cases that look back at the statute from 2006. I believe there's one particularly out of the appeals court whose name is escaping me at the moment. But it went through great detail in looking at it. And the legislature's report at that point was intended to, in terms of expanding this statute, was to focus on gang interference with ongoing criminal proceedings. It had no suggestion that there was a problem in the parole process or that there was some sort of issue that needed to be addressed in the relationship between a parolee and a parole officer. And I would suggest that would be something that would indeed have been addressed had the legislature intended to so vastly expand this, the scope of the statute to address this whole other area that I think is already addressed within the existing discretion of that executive agency.
I'm forgetting this right now, but is all the civil stuff come in 2010, or was that also in 2006?
I believe that was part of the 2006 edition, but I would have to go back and look particularly at that section.
I'm reading a head nod over there. No, it was 2010.
No, 2010. Yeah, as I noted, I was more focused on this particular part.
Right,
but
no, I'm not suggesting. I just was wondering.
Sure.
Let's press that a little bit. What about probation revocation proceedings? Are they a criminal proceeding of any type?
Obviously, that is sort of beyond the scope of this particular case, but
Just asking.
Yeah, and in terms of that, I would have to look more in detail at that. I'm focused more on sort of the parole issue at this point.
Okay.
As I noted, I would respectfully ask that this court review this to determine what the legislature's intention was, what the specific language is, the scope and the legislative history, and the history of treating parole violations different from the criminal system, and in looking at how those systems differ. And respectfully ask that this court reverse Mr. Figueroa's convictions.
I'm sorry, before you sit down, he was violated for parole, I gather.
I don't know. That was not within the record. Actually, it was within the record. He was violated for parole, and oddly enough, not based upon this particular statement. It was based upon some other issues with regards to his case.
All right, thank you, sir.
Thank you.
Good morning, Your Honors. May it please the Court, Jamie Charles, Assistant District Attorney for Middlesex on behalf of the Commonwealth. With me today is Assistant District Attorney Dave Sollett, who was the trial prosecutor in Superior Court.
Do you really think the legislature intended to open up this enormous area that has almost exclusively been left to the parole board to this statute?
I do, Your Honor. I think if you look at the progression of the witness intimidation statute over the years, it has been, as it came up during my brother's argument, been amended several times. And each successive amendment has broadened the scope of the statute. The 96 version of the statute was much narrower than the 2006 version. And then, as Justice Botsford referenced, in 2010 it was amended again to now apply to non-criminal proceedings. So clearly there is an intent behind the legislature's actions to broaden the scope of this statute. And I think that's consistent with the core purpose of the statute, which is essentially to ensure the efficient administration and integrity of the criminal process.
But was there any concern, or based on experience, that the legislature was trying to address when it added parole officers to this category of cases? Were parole officers being lied to and doing nothing about it? Was that a concern of the legislature?
Well, I can't speak for the legislature on this point. There certainly was nothing in the published language that suggested that specifically, but I don't personally have knowledge of the prevalence of that problem. We can rest on the fact that, as I was indicating, the statute itself applies to more than just criminal trials and the process of it applies to the process of a criminal investigation. This court has found
criminal investigation, criminal grand jury proceedings, criminal proceedings. Your view is a parole revocation proceeding is a criminal proceeding?
I would go even further, Your Honor. I would say not only is the revocation proceeding a criminal proceeding, but the period of parole itself is part of the criminal process and qualifies under this statute as a criminal proceeding. If you look at a criminal investigation, that is essentially the entire period during which police are investigating a crime. Any misleading statement made to a police officer during that entire period is going to fall under the purview of this statute and result in a conviction.
I'm sorry. So you're saying that after a person is convicted, the criminal investigation continues?
I'm not saying it is a criminal investigation, but I'm saying that the period of parole falls under other criminal proceedings of any type. If you
okay, well, let me ask you this. When do you say a parole proceeding begins?
Well, as I just indicated, I believe the interaction between a parole officer and a parolee.
Try my question. I mean, I assume there is such a thing as a parole proceeding.
Well, certainly a parole revocation proceeding is a criminal proceeding of any type. Okay. And as this court noted...
And when does that begin? Does that begin upon the filing of a claim of violation?
No, and as I was noting, this court noted in Hersenko in 2011 that there doesn't have to be a pending proceeding for there to be a violation of the witness intimidation statute. There doesn't have to be a proceeding instituted at the time in any case. If the defendant is making these statements with the knowledge that there's the possibility of a proceeding and with the intent to impede the institution of that proceeding, then that in and of itself is enough to violate the statute. But what I'm saying is that our position is broader. The parole officer-parolee relationship has been analogized to the relationship of a police officer investigating a crime. I believe that's the case of, I apologize, Your Honors, Hartford v. Hartford, which was offered by Justice Duffley when she was on the appeals court. Granted, the circumstances of that case were different, but the analogy was drawn between a parole officer who investigates the activities and conduct of a parolee over the entire duration of his period of parole, and a police officer who investigates a criminal action that a defendant is suspected of committing. So I would argue that there are parallels there that justify the conclusion that the entire period of parole essentially is an ongoing investigation. Maybe it's not, strictly speaking, a criminal investigation, but it's certainly an investigation that falls within the contours of the criminal justice system, and it falls under the breadth of the term other criminal proceedings of any type. And again, I do want to go back to Justice Botsford's point to my brother, which is We have to read this 2006 amendment adding parole officer, and as Justice Cordy noted, adding individuals who are aware of information relating to a violation of parole. This has to mean that the statute applies to the parole period, because not only are parole officers rarely witnesses in criminal trials, if they were witnesses or potential witnesses, that's already covered by the statute. Under C-1, a witness or potential witness at any stage of a criminal investigation, grand jury proceeding, trial, or other criminal proceeding. So that covers it. If you're going to be a witness at any stage of a criminal trial, that's covered under C-1. So,
Yeah, well, that's you're a witness because of the statement. You're not. The statement wasn't made to you because you're a witness.
correct.
So it's a reversed order.
I take your point.
Let me ask you this: do you think if we accept your argument, what happens to the whole integrity of the administrative executive parole function? That is, as Mr. Crouch is saying, that you've got officers who are making judgments about whether to violate or not, or the violation. The parole board says, you know, we're going to monitor you for a month, as opposed to the DA swooping in and saying, no, we're going to prosecute you, and you're going to get a minimum 2.5-year and a maximum of up to 10 years in prison. It seems inconsistent with the way that parole operates, very independently of the criminal of the sort of criminal justice system, in the sense of prosecutors bringing cases in court.
Sure. I think there's a couple of points to make in response to that. First, I would just note that parole is not a release from incarceration. It's a variation on incarceration. And for the Commonwealth to have for the parole system to work and for parole to mean anything, the Commonwealth needs to be able to assure that individuals who are on parole are being honest and forthcoming with their parole officers and are abiding by the conditions of their parole, which, among other things,
It's going to be violated. I mean, there is a way of dealing with it.
Sure, but I think we have distinguishable situations. And just, again, to draw the analogy, if you'll bear with me, when you have an investigator, let's say, pursuing a suspected rape defendant, and an individual, let's say the defendant himself, makes misleading statements to the investigator during the course of the investigation that sort of sends them off on a tangent and delays the administration of justice and the pending charges and the trial, he can be convicted of the rape itself, as well as, under the witness intimidation statute, he can receive a separate sentence for impeding the investigation. Likewise here, do we want to treat, let's say, parolees who violate their parole and then are forthcoming about the fact that they violated it? They're going back to jail, potentially. Should the person who blatantly lies to their parole officer again and again, as with this defendant, where for months on end he was carrying on a relationship with a woman who had numerous minor children, spending the night with them, going trick-or-treating with them, when he's a sex offender who's not supposed to be around children, should his consequence be the same as that individual who's forthcoming with their parole officer from start to finish? It's entirely appropriate that he receive additional punishment for disrupting the parole system, for making it more difficult for parole officers to do their jobs if they can't rely on the fact that their parolees are going to be honest and forthcoming with them. And with regards to being prosecuted for every minor violation, the Commonwealth still has a duty to prove not only that the defendant willfully endeavored to mislead his parole officer, but that he did it, and this is the important point, with the intent to impede, obstruct, delay, or otherwise interfere with the proceeding. I think that latter point is objective. So if the parolee, if a reasonable person wouldn't feel that being 5 minutes late to a parole officer meeting and lying about it would realistically result in the complete revocation of parole and reincarceration.
Well, why would they lie about it then if they weren't concerned about their parole being revoked? I mean, isn't that the point?
I think that there are definitely, I can't speak to the personal thought process of a particular parolee, but there are certainly reasons why people lie other than just the mere fact that there is a consequence attached to that lie. Sometimes he may be embarrassed that he slept in that day and was 30 minutes late, and he may not want to admit that he made that mistake. So he'll say, my car didn't start. It's not necessarily absolutely because he feels as though he's going to get violated. He just doesn't want to admit that he slept through his alarm and he's running late for the parole meeting.
Yeah, but isn't this statute really concerned more with the situation where there's a crime has been committed, the police are investigating a crime, and there's some issue as to whether or not a parolee, who is not the suspect or not one of the potential suspects, might have been talking to the subject or the target of the investigation. And the parole officer is interested in that because he's hanging around with a known felon. And the parole officer starts asking him some questions about where were you and did you encounter, John Target of the other investigation, and what's going on here? And he lies to his parole officer about the nature of the matter that's the subject of the other investigation, the criminal investigation.
Again, I don't think it has to be tied to a criminal investigation. I think this court in numerous cases has shown that this statute looks far beyond a criminal conviction. In Hersenko, for example, a threatening letter was sent post-conviction prior to the filing of a motion to revise and revoke. And this court found that that was an attempt to impede a criminal proceeding of any type. In the Hamilton case, where this court concluded that the statute was ambiguous as to whether it applied to threatening conduct once the defendant was removed from the criminal justice system, I think we can implicitly conclude from this court's holding in that case that I believe it related to probation violation and ultimate surrender, that based on what this court concluded, we can imply that had the defendant still been on probation and had the threatening conduct occurred while he was on probation, this court would have found that he had violated the statute. I think that's a fair inference to draw from the decision. Admittedly, it's removed from the interpretation you were conducting there, which is, was the statute ambiguous as to the harm or punish language?
Yeah, but isn't the probation analogy a little bit different? Because isn't that still part of a criminal case?
I would argue that parole is also still part of the overarching criminal case. You have been convicted of a crime and you are put in jail for a certain period of time. Our system allows you to leave your incarceration early. It's a variation on incarceration, not a release, under the condition that you comply with the requirements of parole. If you violate your parole, you can still go back to jail for the rest of your sentence that's tied to the underlying case.
Yeah, but not as a result of anything a judge can do to you. You're going back to jail because of what the probation, the commissioner of corrections and the parole officer and all those people can do to you. It's an executive decision.
But I don't think
probation is a judicial decision.
The fact that it's part of the executive branch, I would argue, does not disqualify this period of parole from the statute. Police departments are housed within the executive branch, and any misleading conduct, I mean, I take the point that I see will be coming with regards to a criminal investigation, but we're talking about officers of the executive branch conducting an investigation, and if you mislead them during the course of that investigation, you go to jail. And so I think it's easy to analogize that to the parole process as well. I realize Your Honors may have more questions on the scope of other criminal proceedings, but I would like to address the question you asked when you took this on direct appellate review with regards to what does it mean to mislead. It's the Commonwealth's position that to be mislead does not refer to only affirmatively misleading conduct. It also applies to endeavors to mislead. It's our position that the parole officer here, for purposes of this case, doesn't actually have to be misled. If you look at the statute, if you look at groups intimidate, harass, or mislead together. And if you look at cases interpreting intimidation and harassment, this court has concluded, I believe most recently in 2005 in the Robinson case, that it is not necessary when a person is charged with intimidating an individual that that individual actually be intimidated for there to be a violation of the statute. Similarly, with regard to harassment, the statute itself defines harassment as having an objective aspect. It would be that a reasonable person, would suffer substantial emotional distress. So it's not a subjective standard, was the parole officer actually misled? It's the defendant's endeavor to mislead that individual that in and of itself would qualify as a violation of the statute.
Am I correct that, not the false statement statute, but another federal counterpart which made false statements, say, to an FBI agent, a crime where those statements were not under oath, required some reliance by the FBI for it to be a crime? And does the word mislead as opposed to the word lie or make a false statement suggest that there must be some reliance?
I don't think it suggests that there has to be reliance. If you look at the 96 iteration of the statute, the language up till 2006 said endeavor to mislead. May I finish my point, Your Honor?
Yes.
And if you look, I believe the appeals court in 2011, Commonwealth v. Rivera, again interpreting the intimidation language, they considered the change in language from endeavor to mislead, and they determined that the goal of the amendment was to broaden the scope of the statute. And so merely endeavoring to intimidate or endeavoring to mislead someone is enough.
But wasn't that in the context of essentially telling a witness that the proceeding was canceled? You don't need to show up, as opposed to transforming this into making it a crime to make a misleading statement?
Well, I believe in Rivera, the defendant had assaulted the victim outside a restaurant and then told the victim, "You better not speak with police."
Well, that's not misleading. That's
that was in
assaulting.
context of intimidating, but it is mislead,
But certainly,
harass,
certainly intimidating does not require reliance nor harassment. But it's curious that the legislature chose to use the word mislead as opposed to lie or make a false statement, because misleading does have some element of reliance to it. And I know that the feds have adopted some reliance requirement to limit the scope of that law.
Sure. I suppose just in one final response, our position is that those three terms, mislead, intimidate, and harass, are grouped together in the statute and should be read in a similar manner. And as neither intimidate nor harass require that the individual actually either feel intimidated and with harass, again, it's a reasonable, objective person standard, that same standard should be applied to mislead. And so we don't have to find that they actually relied. It's would a reasonable person rely on that?
Counsel, we'll have to leave it there. Thank you very much.
Thank you very much, Your Honor.